Welani sanibonani ninjani molweni afusheni thobela enda. Guys, today we have a labor law and we're going to answer some of the questions about labor law. I will try to be fast as possible so that we can answer many questions about a labor law. Okay, let's go. So I'll be answering some of the questions from September 2021 labor law, which was portfolio, but now you write exam 4 hours. So you need to study this one because labor law is very challenging. Okay, let's go to question. One of the question we can use. Let's just scroll so that I can see which one. Okay, let's just scroll. Okay. Which one you can actually pick the one and tell me which one is suitable for you, which one is challenging, so that I can able to assist. Okay, I'm starting with question 4, which some say is challenging. True Workers Union TW and Shining Star Supermarket SSS, which is employer, started 2021 negotiation at the beginning of April and collective agreement was concluded between the parties. So it's a true workers union and it's negotiating with Shining Star Supermarket, which is employer. Okay. In terms of the collective agreement, there will be new working hours and change in the shift system. In June 2021, Triple S informed its employees that the collective agreement will be effective from beginning of July 2021 and will apply to all its employees. Strong Workers Union, this is another union now, is another trade union with members employed by SSS but was not part of the negotiations. SW is adamant that the changes brought by the collective agreement are unreasonable and that the agreement should not apply to its members. With reference to relevant legal authority, advise SW on whether it is possible for the collective agreement to apply to its members even though the union was not part of negotiations with Triple S. So here's what happened. The Strong Workers Union was not part of the agreement. So will their employees bind by the agreement although they were not part of it? This is one some people say is challenging. Well, we have to look to section 23 of the Labor Law Act. Okay. Okay, you must open 213, which defined the collective agreement, which is there. It's a written agreement containing the terms, condition of employment, and matters. Then, after defining it as a collective agreement, you go down to section 23 of the Labour Act. If you can go and open section 23 of the Labour Act, it states subsection 1, it states that a collective agreement binds the parties to the agreement, each party to the agreement with the members of every other party to the agreement insofar as the provisions are applicable to them. Members of a registered union and employees are members of registered trade union, terms of employment, employee. Then section 23 subsection 1 paragraph D state that employees who are not members of the registered union party to the agreement are bound by the agreement if the employees are identified in the agreement. The agreement expressly binds the employees and the trade union represent the majority of all employees employed in the workplace. Okay, this bullet number last is section 23 subsection 1 paragraph D. Okay, you can go and read referencing to the Labour Act. It's just that I'm not finding my Labour Act. I don't know where it is. Then, in a case of a chamber, this Chamber of Mine versus AMCU and others, Section 23, subsection 1, paragraph D of the Labour Relation Act was challenged, which read with Section 65, subsection 1, paragraph A of the Workplace Act. So it says that IMCU argue that the extension of collective agreement to those employees who are not members of unions party to a collective agreement violates the constitutional right to engage in collective bargaining. Section 23 subsection 5 of the Constitution, which means that they are violating Section 23 of the Constitution. The Labour Court held that Section 23 subsection 1 paragraph D is not unconstitutional since it constitutes a justifiable limitation on the right to engage in collective bargaining and to strike. So you must remember this case in Chamber of Mines versus MAMCU and others. So what does this mean? It means that now Section 23 subsection 1 paragraph D is applicable. Remember, it's applicable if the employees are identified in the agreement and the agreement expressly binds the employees and the trade union that is entering into that agreement holds majority. Okay, that's thing that you must know. So to finish up, if the true workers union hold majority, it means that the agreement binds the strong workers union. However, if a strong workers union hold majority, therefore the agreement does not bind all employees because of the section 23 subsection 1 paragraph D. Okay, I know this one. I know now you understand how we answer this question. That's how you conclude. If true workers hold majority, it means that the agreement is binding. If strong workers hold majority, the agreement is not binding based on section 23 paragraph subsection 1 paragraph D. And the case of a union workers, that one that we provided. So let's go to another question very fast. So let's quickly go to question 3.2. Abraham and Sonto, who are labor law students at UNISA, argue about the protection of employees' right to freedom of association. Abraham thinks that this right is important to employees and should not be limited, while Sonto thinks that the right should be limited. With reference to the relevant legal authority, discuss how the Labour Relations Act limits employees' right to freedom of association through trade union, security arrangements, and whether the limitation is reasonable. Okay, this is the question. Now, let's go and answer it very fast so that we can proceed to other questions. Firstly, you need to state the employer's right to freedom based on Section 5 of the Labour Relations Act. There is the freedom of the every employer's right to freedom and employees' right to freedom. Okay. Then you come and discuss the we have a closed and uh, then we have a closed shop and agency shop agreement, which infringe an employee right to freedom of association. Then you start to discuss them. Because I want to go on to others, I will just read what I've written when I was writing this question paper. So this is how it's it. Employees have a right to join or form their own trade union. This is subject to Section 4 of the Labour Relations Act. These rights of trade union are protected by Section 5 of the Labour Relations Act. However, there can be limitation due to closed shop agreement and agency shop agreement. Agency shop arises out of any negotiation between employer and the trade union. These employees who are not in trade union are affected because the agency shop will not apply to them and there will be no deduction from their remuneration. Trade union that opt to conclude agency shop agreement must represent majority of employees. If trade union loses majority, the employer will notify the trade union to look for majority within 90 days. If trade union fails to recruit majority, the employer will terminate agreement within 30 days. Section 25 granted agency fees to be deducted without employees' authorization. Section 25 granted agency fees to be deducted without employees' authorization, so which is unreasonable. In terms of a closed shop agreement, Section 25 granted post-entry. Fees are paid to separate account to enhance employees' social economic interest. These limitations are unreasonable on the basis that they infringe the freedom of association, whereas they even set up their own section from Section 25 and 26 of LRA as they are prerequisite for these arrangements to exist. So this is how you can answer this question. But I've already showed you where there are those arrangements. Arrangements are closed shop agreement and agency shop agreement, which limit the freedom of association. Okay, so guys, pick up any questions that you don't understand from this question paper. Remember, it is a September, November 2021. So you can pick up any one question which you don't understand and ask. Okay, we're going live nowadays, so we can able to teach you anytime where you are available. We are available all the time. So whenever you are available, you can request for a live tutorial, based on your time. So if you are available at 1, you can request at 1 o'clock a.m. If you are available at 1 p.m., you can request based on your availability. Okay. Thanks for watching, guys. Don't forget to subscribe.